Welcome back, everyone, to OpenLine. We are talking about elder law. We have elder law attorney Chris Johnson with us. He's with Takacs McGinnis. He's joining us via Zoom from his office in Hendersonville there. And we already had a call at the top of the show talking about power of attorney, questions about power of attorney. And we'll just go back to the phones here. We have Glenn on the line. Glenn, go right ahead.
Yes, sir. My name's Glenn. I was wondering about a program for veterans called Ages and Attendance for Veterans. What's the requirements eligibility for it?
For veterans, programs for veterans. Did you name a specific program?
I think he said Ages and Attendance.
Okay. All right.
Yeah. Glenn, I recognize that.
Take it away.
I know exactly what you're asking about, Glenn. So, and this is a common misconception. A lot of people refer to the aid and attendance program. Aid and attendance is actually an additional layer on two different veterans benefits. So you have the non-service connected pension, and you asked about the eligibility requirements for that. And so we have your military requirement, 90 days of active service, at least 1 day during a wartime period, and you had to have been discharged with something other than a dishonorable discharge. A lot of people think it had to be honorable or general. That's not always the case. And so if you don't have a dishonorable discharge, you can certainly look at that from the military aspect. Then you need to look at, were you 100% disabled, or are you over 65 years old? And then we have a monetary requirement. And what that program is set up to do is to help you with long-term care costs if your unreimbursed medical expenses are outpacing your income. And so that's where they're going to look at your financial requirements, and they're going to do that in a two-pronged test. It's going to be resources and it's going to be income. So they don't count your home as long as it's on a plot less than 2 acres. They don't count your car, but they're going to count your bank accounts, stocks, bonds, IRAs, cash value of life insurance policies, etc. And what they're going to do is if you have less than 138,000, that's the resource limit. And then what they're going to look at is something called the IVAP, your income for VA purposes. They're going to look at all your gross income. And so let's say you have $2,500 in Social Security and another $1,000 pension. You have $3,500 coming in gross income. If you have $4,000 in unreimbursed medical expenses because you're living in an assisted living facility and you need those care costs, then what's going to happen is they're going to subtract $4,000 from $3,500, and they're going to come up with a negative number. And that's going to mean that you maximize your pension. And so they're going to give you right around $2,400 a month if you are a married veteran who has the need of aid and attendance. And so there's a baseline pension, which is going to be just over $1,900 a month. And that is if you have the unreimbursed medical expenses, but you don't have these the need for assistance with 2 activities of daily living or the need for round-the-clock supervised care. But if you need that, if you need help with 2 ADLs, if you need round-the-clock supervised care, that's where the extra layer of aid and attendance comes in and bumps the pension up from around $1,900 to around $2,400. And that becomes a misnomer because everyone will refer to it as, I want to get the aid and attendance program. What you're really asking for most of the time is to get non-service connected pension with the aid and attendance layer. The other branch you can go is the service connected, what's called compensation. And this is if you have a malady, some type of injury or medical impairment that has its roots in your military service. And so let's say you had a bad back injury and now you're having bad back pain. That's called a primary connection. So, many years down the road, it's like, well, all of this traces back to my back injury in service. You can get compensated for that. And then let's say you're having radiating pain down your legs or neuropathy down your legs, also as a result of the back stuff. Those conditions you can receive compensation for under what's known as a secondary. Those are secondary to the primary issue. If you didn't have the back injury, you wouldn't have the neuropathy, you wouldn't have the radiating pain. And so those are service connected in a secondary way. And you can ask for aid and attendance as a layer on your service connected compensation as well. So those are the 2 big monetary programs that the VA offers. If you're a veteran and you suffer from some pain, if you suffer from a malady, reality that traces its roots back. We call it the nexus to your service, and you haven't been service connected, you should reach out to a VA accredited attorney, to a local veteran service officer, or to the, you can reach out to the VA yourself, but I will tell you it is a very Byzantine process, and it is not a process that you want to face alone. That's why we have VSOs in every county in the state and across the country. Every state has tons of VSOs because the process is so daunting.
Isn't that your background? And isn't that a question you ask right off the bat when people come in, maybe for a loved one? What was their military service? Because there are a lot of benefits that are out there that they may not be aware of. And is that your background?
Yes, so I'm a retired Marine. I served a full career. I loved it. And then when I retired, when I started the second, kind of what I call the second act of my life, I wanted to be in an area, in a field where I was able to give back, and specifically give back to veterans. And elder law goes hand in glove with that. And we've got big veteran communities where we're located in Sumner County, and frankly, all over Middle Tennessee, and up obviously in the Clarksville area. And it just feels very good to be able to give back as far as those things go. And yes, if you don't know or unsure, you need to reach out to someone who knows what they're doing and walk you through the process, because when someone knows how to handle these claims, you're not going to get caught in what I call the VA spin cycle, where you made just an innocent mistake on a form, because there are so many different VA forms, and if you just check a box wrong or fill out one of the numbers wrong, you made a terrible accident, it gets sent back to you, and that process of going back and forth is going to delay your claim by months and months. And that's what we want to avoid. We want to get people who are eligible for these claims, get their claims processed very quickly and correctly, so that they can start receiving the benefits that they've earned.
Very interesting. Let's go to Mike. Mike on the phone here. Hello, Mike.
Yes, hello.
Go right ahead.
Yeah, I have two questions for you. First of all, what is the difference between power of attorney and durable power of attorney, and does durable power of attorney include health care? The second question is, I need to name a power or durable power of attorney. I have an adult son and daughter. Is it wise to name both of them power of attorney? Thank you.
Good questions. Thank you, Mike.
Yeah, those are great questions, Mike. In fact, you asked one of my favorite ones is the second one, but let me take them in the order that you gave. Durable power of attorney, durable general power of attorney, vice straight general power of attorney. Here is the difference. The durable power of attorney survives during incapacity. And what that means is the whole idea of having a power of attorney is, generally, if I can't make decisions for myself, like I've provided my wife power of attorney for me. And so if I'm in a car accident, if I have a stroke, if I have some terrible medical event, I need her to make decisions for me, because my life still continues. Like, there's going to be bills to be paid. She's going to have to handle all of our finances. It's April, so it's tax season. Taxes are due here in another couple of days. And at a minimum, she'll have to be able to legally file an extension. She can't do that if she doesn't have the legal right to sign my name. So power of attorney, legal, financial, is what we generally think of when we're thinking of a general power of attorney. Again, that's that copying and pasting so that they can sign my name, and then they'll sign by AIF their name. That gives them the legal authority to sign my name. What makes it durable is that in what I was just describing is I'm incapacitated. Well, one of the things that you lose when you become incapacitated is the ability to revoke the power of attorney. And so the law doesn't want to have a power of attorney in force that you didn't want to have in force. And so if you don't have the ability to revoke it, the law basically says, hey, that power of attorney is no good unless you have explicitly stated in your power of attorney that language that says, I want this to survive my incapacity. And that's what makes it durable. I would almost never recommend someone to do a power of attorney that isn't durable, because 95% of the time, that's exactly when you need it. You need it when you can't make decisions on your own behalf. So that's the difference between durable and non-durable. Now, you asked about medical. Medicals are separate powers of attorney most often. And I always say a medical power of attorney almost by definition is durable, and here's why. With a medical healthcare power of attorney, as we refer to them, when you are making healthcare decisions, you're in the room. You're talking to your doctor. And if you have capacity, that's going to happen. A healthcare power of attorney is generally only needed when you lack that capacity. And so the healthcare power of attorney almost by definition is durable, because that's when those decisions have to be made. If you have capacity and are able to communicate, you're in the room with your doctor, you're going to be making those decisions yourself. So that's really the interplay of a durable general power of attorney and a general power of attorney. Now, there's another one you might not have heard of known as a springing power of attorney. This does just the opposite. It's actually not legally in effect until you lose capacity. But mechanically, that has a lot of pitfalls, because you need to go get a letter from one, sometimes two doctors stating that the person is incapacitated. And generally, mechanically, that's very hard to do, and not the burden that you want to put on your agent when they're trying to do all these other things. They're going to be frazzled. They're obviously in close relation to you, and you don't want them at a very bad moment in their life, because they're worried about your health, your well-being. Are you going to live through this? That they have to rush to the doctor and say, I need this letter that tells me I'm in charge. The doctor is going to be reluctant to write that letter, and I understand why. And so that's generally, a lot of people think a springing power of attorney is a wise decision, when in fact it very much works against them when it's needed most. On your second question, it's one of my most favorite questions. I get this with a lot of clients. So we've got a son and daughter. My guess is because you're considering both, they're probably both candidates to be your power of attorney. And like a lot of parents out there, you want to treat your kids equally. I want to treat them fairly. I don't want one to feel like they're the favored one over the other. And so I want to make them co-powers of attorney. The problem in that scenario is you've made a voting block of two. And the potential exists. You know, I have siblings. My kids are obviously siblings of one another. If you know anything about siblings, we can disagree on all sorts of stuff. And it doesn't make one right and one wrong, or one bad and one good, because reasonable minds can disagree on a lot of things. And it doesn't make one person the smarter one and one person the dumber one. And if they don't agree, then oftentimes the power of attorney cannot act. And then what happens is all of that planning you did ahead of time to make sure things worked well when you were incapacitated, now you've basically messed that up, because you've made a 50-50 voting block, and now things get frozen, and then they end up back in the courtroom, which is exactly where you were trying to have them avoid in the first place. So I often say, remind the children that these are jobs, they're not titles. Doing a power of attorney, it's work. And so it's not like, look at me, I'm the power of attorney. It's like, yeah, look at you. You've got more work than the one who isn't. But if parents really feel that need to be even-handed and work things out as fairly as possible, make one child the healthcare power of attorney, one child the durable general power of attorney. Make one child the trustee in the trust, make the other child the personal representative in the will, and then have the other back the primary up. And that way you have redundancy, and you avoid that pitfall of them disagreeing. Don't sow the seeds for discontent down the road.
Yeah, that's why you do so much of this. Don't sow the seeds for discontent. Now, I didn't realize you could name two people as your power of attorney, but then they would both have to agree, which then begs the question,
That's right.
Okay, what if you have three kids? Could you make all three of them?
I've had it, and I actually had a client. That's so funny you bring that up. And I had that, and I had a client who didn't just ask if they could have three. They demanded that all three of their children be co-powers of attorney. And remember, attorneys are counselors. We don't order our clients and tell them what to do. We listen to their needs, and we set up what we think are the best courses of action. But I give my clients options, because what I think is in their best interest, it doesn't mean that's exactly what they want. And so I had that scenario. I ran through all the pitfalls. I won't go into the story. I will just tell you, I finally, when I wasn't convincing my client, and I was frustrated because I knew this wasn't a great decision, but I wanted to know why. And I asked my client why, and I will tell you, they shared a story with me that really, I think, changed my outlook on how I meet with clients, frankly, because listening is the very best thing you can do as an attorney. And the story that was shared with me was exceedingly powerful. And I understood, A, why my client wanted what they wanted, and B, I understood that although it might not be the best decision for the generic person, it gave him very much the peace of mind he was hoping for. And because I had listened to him, he let me craft in some kind of safety parameters so that what he wanted didn't end up working against his best interests. And so I made 3 co-powers of attorney, but we set up some safety checks if there were disagreements that still allowed decision making to happen. And that's one of the best things that you can do, any attorney out there, is listen to your client, understand not just what they want, but why they want what they want. Because when you understand that, that's when you're doing your very best work.
Can you share the story, or would that give away the client?
It wouldn't give away the client, but I think we have attorney-client privilege. I know it would be generic, but I think just suffice to say they served as power of attorney as a child and had to make some hard decisions, and they didn't want that to fall on singular shoulders.
That is hard.
And there's much more to it, but people don't think about that. They are leaving oftentimes very difficult decisions to their children. And so this will give me my other opportunity to plug. If you make one of your children your power of attorney, let them know what you want, especially when it comes to healthcare. Just don't tell them, hey, you're going to make the decision on whether to pull the plug or not when I'm, old and suffering a medical event. Tell them, do you want extraordinary measures? Do you want a feeding tube? Do you want chest compressions? Think about those things and have those conversations with your children, because I will tell you, if you don't, and they're forced to make that decision in a vacuum with no help from you, that will be a burden they'll carry for a very long time. And I encourage every one of my clients, in fact, we give them a workbook, Do You Know My Wishes, that kind of helps them lay that out for their kids or whoever their power of attorney is, because we want things to work the way they want them to work.
Wow, that is powerful. Okay. All right, very good. Mike, thanks for that question. We will take a break. Come back. Continue to take more calls. If you want to call in, there's the number, 615-737-PLUS, 615-737-7587. Take a break. Be back right after this.